And look, after this Supreme Court ruling, your home might already be on a county watch list. And the family I'm about to show you found out what that list does the hard way. They owed $2,242. They disputed it. They fought it and won twice. And the county sold their $194,400 house at auction anyway for $76,008. Then kept the money, all of it, at first. And on June 23rd, the Supreme Court of the United States looked at those numbers and said the math checks out. 9-0. Now, if you played by the rules, if you went without so the house got paid off and figured nobody could now touch your home now that you owned it free and clear, this ruling was aimed at you. Because here's what almost nobody watching the evening news coverage understands. There is a list in your county. It's public. It's updated constantly. And that list isn't new. What's new as of June 23rd is what it can cost you to be on it. The Supreme Court didn't turn this machine on. It took the safety net off. And it's running right now while you watch this. And it decides whose house gets fed into the machine you just saw eat a family's home over $2,000. Your address is either on that list or it isn't. And at the end of this video, I'll show you exactly where that list lives and how to run your address. 10 minutes, costs nothing. And let's start with this family that did everything right and still ended up on it. Because the lesson is not pay your taxes. They were winning in court. The lesson is worse and more useful. Because once you see how the machine works, this senseless story will actually make sense. Picture this. You get a parking ticket you know is bogus. So you go down to the clerk's office to fight it. You wait in line behind a guy who smells exclusively of damp pennies. You make your case, and the clerk looks at the paperwork and says, "You know what? You're right. This is a bad ticket." And you win. And while you're standing at that counter winning, the tow truck is hooking up your car. Because the tow lot is a different department. The tow lot doesn't take calls from the clerk's office. The tow lot doesn't care about your feelings, your legal victories, or the concept of linear time. The tow lot has one job. The list said hook up the car and tow it. So it does. That's the county tax system. There are two machines. Machine 1 decides whether you owe the money. Machine 2 takes the house. And the nightmare that the Supreme Court just blessed, 9-0, is this. Machine 2 doesn't stop just because you're beating Machine 1. Hold that picture. Meet the family. Central Michigan. A man named Scott Pung buys a 3-bedroom ranch on half an acre for $125,000. It's his primary residence. He files the paperwork for Michigan's principal residence exemption. That's the lower tax rate you get on the home you actually live in, versus a vacation place where you occasionally go to drink Merlot and ignore your emails. And notice they call it an exemption, like they're doing you a favor by only taking some of your money instead of all of it. They write the rules so that simply living in your own house sounds like a government loophole. Well, he files it correctly. He raises his family there. Scott dies in 2004. His wife, Donna Marie, stays in the house. She dies in 2008, and their son Mark moves his own young family in. Same house, same family, 20 plus years. And under Michigan law, that exemption continues automatically as long as the family keeps living there. No refiling required. And the courts would end up confirming exactly that, twice. Now, hold on, because in 2010, the local tax assessor decides, on her own, like a minor deity waking up on the wrong side of the bed, that the family should have refiled the exemption paperwork after Scott died. They shouldn't have. The law says they shouldn't have. But she strips the exemption anyway and retaxes the family home as if it were a vacation home. Backdated, years of it, penalties stacked on top. So a family that filed the paperwork, paid the mortgage, buried 2 parents in that house, and never missed the real bill, suddenly owes $2,242. Charges a Supreme Court justice would later flatly call improper. The Pungs did what you're supposed to do in America when the government gets it wrong. They went to court. So round 1, the Michigan Tax Tribunal. That's the state's referee for property tax disputes. The Pungs win. The tribunal says the exemption stands. The family doesn't owe the second home rate. Clean win. You'd think that's the end of it. Here's the assessor's response. And to be crystal clear, this quote is not from a blog or a comment section. It's quoted verbatim in Justice Thomas's opinion in this very case. The assessor said, "I don't care what he says," and she denied the exemption again. Say with that, a government official looked at a court ruling, the thing that's supposed to be the final word in this country, and went, "Yeah, no, I'm good," like she was declining a flyer for a local improv show. And nothing happened to her. The bill stayed on the books. So the family fights a second round, real estate courts this time, and they win. Again. 2 rounds, 2 wins. Same answer on the exemption. The family is right, the county is wrong. So when that disputed $2,242 kept sitting on the county's books, the Pungs refused to pay. I mean, why would they? They just won. Twice. Writing that check feels like surrendering to a rogue municipal warlord. It's the principled move. It's also the move that cost them the house. Because remember, the tow truck? While the family was winning at the clerk's counter, Machine 2 never stopped moving. In Michigan, once a balance goes unpaid long enough, the process runs on autopilot. The parcel gets flagged, then forfeited to the county, then foreclosed. A couple of years, start to finish. And here's the design flaw. The collection side never re-asks whether the underlying bill was legitimate. That's not its job. And they call that step forfeiture, which is a beautiful piece of bureaucratic camouflage. Forfeit implies you walked away. You didn't walk away. The machine just quietly redefined your property as their property while you were busy trusting the court system. The county took title to the home in 2015, locked it in on appeal in 2018, and in 2019, April 30th, by the family's own court filing, Mark Pung, the son, with his wife and young child, was evicted from the house. Over $2,242 the family swore all the way to Washington they never owed. The family says the critical foreclosure notices never reached them. A trial court even agreed before an appeals court reversed and ruled that the county had tried hard enough. The county, for its part, says it mailed notice again and again and again. So no, these folks weren't dodging a bill with their fingers in their ears. They were in courtrooms, fighting, winning. The machine took the house anyway. Now it gets worse. Let's do the math out loud. In 2019, the county puts the home up at its tax auction. The county's own assessment, the number they used to tax the family all those years, they said the house is worth $194,400. It sells for $76,008, 39 cents on the dollar, and the county keeps every penny. Not the $2,242 they claimed they were owed, all $76,000. The family got a bill for $2,000 and an eviction notice, and the county got a house. The family had to sue just to pry back the difference, $73,766. So add it up, the $2,242 debt credit plus the $73,766 they clawed back means the family got $76,008 of value out of a house the county itself said was worth $194,400. Roughly $118,000 of equity just evaporated. Decades of payments gone into the gap between real value and one fire sale morning. Oh, and the auction buyer flipped the house on the open market. Sale price $195,000. Almost to the dollar what the county said it was worth all along. That's nearly $119,000 of daylight between what they paid and what they sold it for, before expenses, for just showing up with cash. Now here's the part I can't prove, but here's what I think is happening. I've spent 20 years in real estate. I've stood at these auctions. I know the cash buyers who live for them. And what I can't prove here is who knew whom in that room, or why a house worth $194,000 went for $76,000 with no floor under it. I don't know, maybe it's nothing. Maybe it's just what happens when the government liquidates your biggest asset at a government-sanctioned garage sale for human misery. But I noticed something. The question of whether that auction was fair, whether the process itself was clean, that turns out to be the one question the Supreme Court refused to close. So file that away. It's coming back in about 90 seconds. Because you saw the ruling, 9-0, and likely concluded all 9 justices must have been crooked. I read the opinion, so you don't have to. And the real story is more interesting, and it leaves the door open. Here's what the court actually ruled. When the government forecloses and auctions your house for a tax debt, the Constitution's just compensation means whatever the auction fetched, minus the debt. Not what the house is actually worth. The auction price is the number, as long as the auction was fairly conducted. In other words, if somebody buys your original Picasso at a yard sale for $4, then legally speaking, you only ever had a $4 painting. The $118,000 gap between auction price and real value, constitutionally, that's your problem. The court said homeowners can generally avoid tax sales, refinance, borrow, sell, pay. And in fairness to the majority, that's the cold truth here. The Pungs had years of chances to write one $2,242 check under protest and keep fighting. Being right doesn't stop the clock. That's the lesson, and it's a brutal one. But two things in this ruling did not go the county's way, and your newsfeed skipped both. One, the court sent the case back down. The lower court now has to decide whether the family properly preserved its challenge to how this auction was run, and if it did, whether the process was actually fair. Every homeowner lawyer in America just underlined that word. That suspicion you felt 2 minutes ago about the auction room, still legally alive. This case is not over. And two, Justice Clarence Thomas, in his own written opinion, joined by Justice Gorsuch, said this about the county, on the record. What Isabella County did to the Pungs was, quote, wrong, and on my initial view, likely unconstitutional. A justice who voted with the 9-0 still called the county's conduct likely unconstitutional. That's how narrow this ruling is. And then Thomas ran the county's logic forward. And this is the thing to remember from this ruling. Under the county's theory, he wrote, picture a family that owns a $400,000 home and owes $1,000 in taxes. The government could seize the house, sell it at auction for $1,000, and owe the family nothing. Zero surplus, zero compensation. And in a footnote, he added that this example is, quote, not far-fetched. Local governments, he said, engage in practices like this with some regularity. Here's the line I want you to text to your spouse tonight. A Supreme Court justice just confirmed the county could legally sell our house for a fraction of what it's worth. And as long as the auction is fairly conducted, the only number the Constitution protects is whatever it happens to fetch. Because here's the ambush inside the ambush. When your house is paid off, the bank leaves the room. No escrow paying the taxes automatically. No lender monitoring the county's books. No one flagging a delinquency before it snowballs. The easiest people for this machine to blindside are the ones who did the most right, the ones who paid the damn thing off. The warning doesn't look like a warning either. It looks like ordinary government paperwork, which is exactly why it's so easy to miss. And then, one day, it's an auction notice. Now think about what every county treasurer in America heard on June 23rd. Your auctions are safe as long as they look fair. If you're running that office, is your list now getting shorter after that ruling or getting longer? That's not a conspiracy theory. That's an incentive. So the watch list, here it is. And here are the 3 moves. Do them tonight. The whole drill is maybe 20 minutes, maybe. And I'm not your attorney and this isn't legal advice. It's a map. Move 1, run your address on your county treasurer's delinquent tax roll. That's the watch list. No secret database, just the official running record of every parcel with a balance attached. Your local property tax authority keeps it. The county treasurer, tax collector, whatever your state calls that office. Many places have it searchable online. And if yours doesn't, 1 phone call, that's all you need. That'll do it. Now the record is the intake pipe for the whole machine. Search your address. You are looking for one thing, a 0 balance, not a I'm pretty sure I paid. Look for the 0. 0 in the county's own records, because the county's records are the only ones the tow truck reads. If your home is paid off, do this twice a year, because nobody else is watching for you anymore. Move 2, pull your assessment record and check that your exemption box is still checked. Remember, the Pung's nightmare did not start with a missed payment. It started with an official quietly removing an exemption they'd earned. Your homestead exemption, your senior freeze, your principal residence status, whatever your state calls it, it lives on your assessor's record, and it can be revoked without you noticing until the bill lands. Pull the record, confirm the exemption, and while you're in there, look at the value they've assigned to your house. If it looks out of line with what similar homes around you actually sell for, or it's blowing past your state's cap, find your appeal deadline before it passes. I made it easy for you and posted a resource for this at fightmyassessment.com. I'll put that link down below. Move 3, fix your notice channel and adopt the doctrine. Make sure the treasurer and assessor have a mailing address you actually check, and sign up for electronic notices where offered. The Pungs say the critical notice never reached them. And the doctrine is the whole lesson of this story in one sentence. If a disputed bill ever lands, stop the collection clock first, then fight. In some states, that literally means paying the bill and writing paid under protest. In others, it's a specific form, a specific office, a specific deadline. The paperwork, it varies. The principle doesn't. A paid bill can't feed the machine. The tow truck has nothing to hook. And a properly preserved protest keeps your fight alive. By doing this, you've moved the war from the side of the table where they can take your house to the side where the worst case is they hold your $2,000 while you win it back. So, the day some strange bill arrives in your mailbox, your first call is to somebody who knows exactly what your state requires. The Pungs had brilliant lawyers for the war, a decade of them. What they didn't have was somebody in their corner on day one, when the first weird letter showed up, saying, here's the exact move that stops the clock in your state. Now, let's go sue them into the ground. That one conversation is worth more than 10 years in court. And having a lawyer you can actually call the day a strange letter arrives is the whole point of a legal plan. I've got my own lawyer on retainer for less than one pizza night per month. If you want that type of protection from the bullies and some sleep well at night comfort, get the details at bullyproofmylife.com. Link, it's down there too. Here's the thing with this whole story. The Pungs weren't deadbeats. They were right. Morally right, legally right. 2 courts said so. And they still lost the house because they made a bet most of us would have made, that being right was the same thing as being protected. It isn't. Not in this system. Not yet. So you've got 2 plays in front of you. Play 1, trust that your paid off house, your clean record, and your sense of justice will protect you, the way the Pungs trusted 2 court victories. Or play 2, spend 20 minutes tonight, run your address, check the exemption box, fix the notice channel, and make sure the machine never learns your name. One play feels righteous, the other one keeps the house. And look, the part of this case I can't shake isn't even the auction. It's that the Pungs never got hurt by a criminal. They got hurt by a licensed official, doing her job the way the system let her do it, while everybody assumed somebody was checking her work. Well, nobody was checking. So when I finished this story, I started asking the obvious next question. Where else in your life is there a licensed professional you're trusting that nobody is checking? And I hit a Department of Justice lawsuit that made my jaw drop. The biggest health insurers in America, names you'd recognize from the evening news commercials, they were accused of paying hundreds of millions of dollars in kickbacks to the licensed advisors seniors trusted to pick their Medicare coverage. The same play you just watched, the person you assumed was on your side, paid to be on someone else's. That's why I pulled this next video here for you to watch next, because the Pung has lost $118,000 in one morning. The wrong Medicare plan does it slower, thousands a year, every year, so quietly most people never feel it. And the defense is the same drill you just learned. Nobody is checking this for you. And checking it yourself, it costs nothing. So watch this next. God loves you, and so do I. Take care.